Hi everyone, we're going to make a start. As you know, we're running a little bit late, and if you were hoping that this would be a really short session, I'm afraid it's not going to be a really short session, but afternoon refreshments have been cancelled so that we can talk for longer. But it'll be a slightly shorter session, so I'm sorry about that, but we are running late. What I want to do is just tell people very briefly what this was all about. The full report was published just over 2 weeks ago. I know you'll all have read it and annotated it, but just in case you haven't, I'm just going to run through the main points and tell you what it was all about. So this started when Dan here wrote an article in LAG about the problems of how potentially incapacitated litigants in courts are dealt with and the gaps in the rules. And the CJC agreed to set up a working group, and Dan and I chaired that working group, which ended up in the report that was published a couple of weeks ago. So I'm just trying to, I'm pressing the wrong thing. Really briefly, I just wanted to give you the kind of highlights of what the report was about and what the problem was that we were trying to address. And the problem is really that the civil procedure rules are very clear that a person, a party in civil litigation who lacks litigation capacity, the mental capacity to deal with litigation, must have a litigation friend. They're a protected party. It's very clear. And the rule provides that if during the proceedings a party lacks capacity, no steps should be taken until a litigation friend is appointed. Now, the problem is that there's no provision for cases in which it's not absolutely clear that a person lacks capacity. And this is a problem that was identified more than 20 years ago in a case called Masterman, Lister and Bruton, when Lord Justice Kennedy set out what would happen in a case where everything works well, which is that a responsible solicitor acting for a claimant or defendant who has doubts about their capacity will seek a medical report, and if the opinion suggests that they lack capacity, then the solicitor arranges for the appointment of a litigation friend, which works great if the party has got a solicitor, if funding is available for a medical opinion, and if the party doesn't dispute that they may lack capacity, and should say if there's a suitable litigation friend who can be appointed. We didn't really look at some of the issues arising in relation to litigation friends. We were focusing really on court procedures. But as Lord Justice Kennedy observed, there was no, and there is no provision in CPR 21 or in any of the previous court rules for how a judicial determination of the question whether or not capacity exists. There's no provision as to how that will happen. And he recommended 22 years ago that the Rules Committee should consider the issue, but that in the meantime, courts should always, as a matter of practice, at the first convenient opportunity, investigate the question of capacity whenever there's a reason to suspect that it may be absent. So there's very clear guidance there. The problem, I think the two main issues, there should be a judicial determination, but there is no provision, no rules, no guidance as to how that determination should be conducted. And the court should, at the first convenient opportunity, investigate the question of capacity. Again, there's no provision as to how that investigation will take place, and no resources really. So these are the issues we were considering, and we considered the issues in the following headings. First of all, we looked at the nature of the issue and the role of the court, general principles, and then looked at the different stages, how the issue is investigated, how the issue is identified in the first place, then investigated and determined, and what should happen to the proceedings pending this decision. And the big issue is there will be cases where some funding is needed to pay for some of this to happen, and that's going to be the big change which we have recommended. So the test is the test as set out in the Mental Capacity Act, and I'm sure we all know it's decision specific, and this is specific to litigation. So it's about being able to understand and make the kind of decisions that are necessary to conduct litigation. The presumption is that someone has capacity unless there is evidence or it's established that they lack capacity. And I think one of the things we felt was that the presumption of capacity is possibly being used as a way of avoiding addressing the issue, because clearly if it hasn't been determined, you have to presume capacity. But we feel that that probably means lots of people who lack capacity are falling through the net. I mean, these are the statutory principles, and I've set these out just because I think these are the most pertinent. But a person is not to be treated as unable to make a decision unless all practicable steps to help them to do so have been taken without success. But what this raises the question, if you're talking about perhaps an unrepresented litigant in person, who is going to provide that support and that practical help to assist someone to make a decision? So I think it's fair to say we know this is a massive issue, and that what we've done, I think, is the first step in starting a process of trying to address it. There is case law on what litigation capacity means, and as I say, it's decision specific. A person may have capacity to conduct a simple case, but not a complex one. And what we heard in the consultation that was conducted was from a lot of PI and clinical negligence lawyers about the fact that excuse me, a person may have the capacity to conduct their own litigation, but not the capacity to administer a large award of compensation. So just going through the headings, because we do want to hear from you. The nature of the issue and the role of the court. Where there isn't a dispute, the litigation friend is appointed either by filing a certificate of suitability or by a court order. And it's not an inter-parties issue. It's not something that the opponent has any say in, really. So it's what we decided. It's really, we're talking about the court exercising its case management functions in a sort of quasi-inquisitorial role. But it's easier to say that than to work out how this will work in practice. And issues arise. What if there just isn't the evidence available to make this decision? What if the person is unrepresented? What if there is no funding for a report? How does it work in practice? So these are the issues we were grappling with. So going through the headings, as I say, identification of the issue, I think, is really problematic. And currently, there are fewer opportunities for the courts to have face-to-face interaction with litigants since the closure of court desks, court counters. And I think if we are going to more digital justice, we're going to need to really think how are these issues picked up when there isn't a face-to-face hearing. And there are more unrepresented litigants in the civil courts. So I'm not going to go through all of our recommendations as in the report, but in this respect, we recommended better training for judges to identify the issues, and clearer duties on legal representatives, clearer professional duties. That is to identify issues with your own client and possibly with an opponent, and also clearer duties on parties if a party thought there was an issue with an opponent's capacity, how could that be raised? So these recommendations are training for judges and clearer professional duties to identify the issues in the first place. Then a much bigger question even is, how is it then investigated if it seems that there may be an issue? What evidence is needed? Is medical evidence always needed? Well, the case law says not, but it may well be that in most cases, given the nature of the capacity test, a medical report will be required. A difficult issue, I think, was what powers should the court have to order disclosure of medical evidence, possibly against the wishes of the party. But I think the big one is who does carry out this investigation. The Equal Treatment Bench Book says, in a rather blasé fashion, if a judge is concerned, they can write to the GP who is treating the person and get a report. I mean, this raises huge questions, but certainly I think none of the judges on the capacity working group thought that was a very workable suggestion. The official solicitor, well, they can only act if funding is available and they have very limited resources. And we concluded that what is needed is a new model. This needs to be delegated to someone else to investigate, and it needs to be done on an explicit basis. I think what we felt was that hearing the responses in the consultation, there are a lot of workarounds. There's lots of ways of making things work, and it's not always clear what the basis of that is. Judges are trying hard to make things work. There's a lot of reliance on legal aid practitioners, law centres, charities to do lots of extra unfunded work to try and hold it all together. And we're recommending that there needs to be a delegation. It needs to be done explicitly. And we considered a number of models. And I think it's fair to say we didn't come up with any model that we thought was perfect. And some of the, certainly, I think, is it the qualified legal representatives that have been introduced for domestic abuse cases isn't working terribly well, as I understand it. But there needs to be a clear, explicit delegation. Because obviously the court doesn't have the resources to do that. Perhaps even more difficult was, how is the issue to be determined at a hearing? So if it's clear, if there's a representative, if there's funding, and if the party isn't disputing it, then a report can be obtained and a litigation friend appointed. So we're not suggesting that should change, but we were considering what happens where the party is represented, and their representative does think that they may lack capacity, but the party disputes that and may not want to cooperate with an investigation. And what happens at a hearing, if that's the case, where the legal representatives are actually in dispute with their own client, or the party is not represented and the issue has been raised by the court or by the opponent. But the big issue, I think, which we didn't agree on as a working group, is how that hearing should be conducted. In open court, with all parties able to attend, in private, with privacy and anonymity provisions, and what's the role of a representative who is in dispute with their own client. The representative has a professional duty to raise the issue with the court, but their client may not agree that they lack capacity. And maybe unsurprisingly, we weren't able to decide this, and it's not really our decision as the Civil Justice Council. We said it's really for the court to decide whether the hearing is in private or in public, and to what extent, bearing in mind that the information the court's dealing with is confidential, likely to be subject to legal privilege that may prejudice the party's substantive case. The party may be not able to protect their own interests because of the lack of capacity, balanced against the importance of open justice and the recent trend towards greater transparency in both the family courts and in the Court of Protection. And also there needs to be a judgment which can be appealed. So it's an incredibly difficult issue, which we were very divided on, I think. And the other thing, the legal representatives we felt needed much clearer professional guidance as to their role if they'd raised the issue against their client's wishes and then were part of the determination. So really difficult issues, I think. Less difficult was what should happen to the substantive proceedings pending a determination, because there's clearly going to be a time lag between identifying an issue and there being a hearing to determine it. And while the issue is investigated, it may take some time. And we did agree that the starting point should be that no further steps should be taken without the court's permission, and there should be a sort of balance of harm test similar to that in the Family Law Act when you're dealing with injunctions and ousters. But the big one is funding. There will be cases where there will need to be funds available to pay someone to conduct the investigation, to instruct experts, to pay for an expert report, and perhaps to represent at a hearing. And this is, I think, a great case from Northern Ireland Court of Appeal. the affordability of justice, the availability of legal representation, and the provision of support measures such as litigation friend are closely related and all inextricably linked to the fundamental right of access to a court and a fair hearing. And without funding, we are going to end up paying lip service to the common law right to a fair hearing. So we are recommending that a fund of last resort be created for cases where there is no existing funding. We did consider the possible sources of existing funding. Legal aid, if the person is eligible for legal aid, that's not usually a problem in our experience. A properly resourced official solicitor would be a great thing. In some cases, an opposing party, particularly if they're the claimant and they're a substantial body like a local authority or perhaps insurance company, and they need the case to proceed, they may be willing to fund the necessary steps to establish capacity or lack of capacity. But I think there's no avoiding the fact that there will need to be a fund of last resort, because there will be cases where no funding is available. And without that, people are going to not have access to justice. In the meantime, and in the hope that there might be someone in this room from the MOJ or the Legal Aid Agency, we did recommend that there were some things that could be done relatively simply. For example, non-means tested legal aid for the limited purpose of determining a person's capacity is a possibility. And even easier would be a very simple amendment to the rules about the signing of legal help forms, the early sort of legal advice. What we heard is there's a huge problem. If you have a client who may lack capacity, you may not be able to get the evidence that's necessary or get the forms signed to do the work to establish that. And it could, in my opinion, be so easy for the rules to be changed so that a provider, a solicitor, could sign the forms on the basis of a reasonable belief in the person's eligibility. I mean, I'm sure lots of people have. I've certainly had cases. You absolutely know your client has no money and is on benefit. It's just that you can't get the documentation that the legal aid agency requires. So, in summary, those are some of our recommendations, and I think what was recommended by Amy here, who was provided the secretarial support, was that we should be very focused in the recommendations and also identify who the recommendations are aimed at, rather than have a report that just says all this stuff should be done. So there are some recommendations which are aimed at changing the procedural rules, and that's really the job of the Civil Procedure Rules Committee. Professional regulatory bodies, I think that will come later when the procedures have been established, but there needs to be clearer guidance for legal representatives. The Judicial College for better training for judges, and one thing that was suggested was that there should be mandatory face-to-face training on a regular basis, not just online modules, but face-to-face training and updated training. HMCTS, MOJ, I mean, one of the things actually targeted at HMCTS is about data. I don't think we know how many people, even how many litigation friends there are acting in the civil courts, and that should be data that's relatively easy to capture. It'll be of limited use, but it would be useful to have something to show that, because we have no idea really of the scale of the problem, save for anecdotal evidence. MOJ LAA, Legal Aid Agency, for amending the legal aid rules, and the CJC, with our new kind of more focused strategy, will monitor what we've decided with all the reports. It's not just to put out a report, but to then look in a year or 18 months, well, what's happened? Has it been effective? Has anything improved? So that's what will happen next. And that's all I wanted to say, just as a very brief summary of what we did. And I don't know, if Dan, if there's anything you wanted to add to that. But,
I don't think so. That's very helpful. I'm aware that I've offloaded most of the burden of that presentation to, or all of the burden of that presentation to you. But I think rather than add anything, I've heard myself talk about capacity for at least 3 years now, and I'd much rather hear from people in the room. So I don't think I have anything to add. Are there any questions in the room or online? I think we've been doing it by way of hands up online.
Oh, sorry.
Oh yeah, sorry, whichever order.
Question for you, Dan. direct access barristers, obviously the lay client remains a litigant in person for the conduct of the litigation. So in your section 4.1 onwards, I understand that under the rules, legal representation would include a direct access barrister, but the expectation, other than potentially informing the court, there needs to be some difference within that. Otherwise, it might be misleading. I appreciate that you're going to have to liaise with various different bodies. There is a direct access reporting panel that reports to the Bar Council Legal Services Committee. But that seemed to me to be the glaring difficulty in the title legal representatives, which does not reflect the reality these days. It might be different for an unbundled solicitor because they will have potentially some conduct of the case, but not for a direct access barrister.
I think it's fair to say that we didn't give, I don't think, to my memory, great specific considerations to the question of direct access. It's not something that I'm familiar with personally. I mean, I think the will, to an extent that a direct access barrister is instructed for the purposes of particular hearings, their professional ethical duties will continue to apply with appropriate modification. Obviously, there will be a gap in the sense that a litigant in person won't have somebody on the record acting for them in the same way as a solicitor. And I suppose some thought may need to be given to how far a direct access barrister's obligations might extend and in what circumstances. I'm afraid that's something I haven't given a great deal of specific thought to.
Yeah, I think that's the point. It's fairly prescribed as to what the direct access barrister can do. And certainly going out trying to find a litigation friend in circumstances where there is an issue of capacity will not be part and parcel of the remit. There's the duty to the court, yes, and a duty to protect the interests for that particular purpose that you've been instructed. So it is quite a minefield to, and this language is rather loose, I think, to cover that position.
I think 2 points that will become important in that circumstance. One is the recommendations we've made about the duties of other parties and representatives of other parties. I mean, that is precisely to, if we treat a litigant in person with direct access as just in the broader category of litigant in person, those recommendations are intended to address the problems that arise because of litigants in person not having a representative who's focusing on those matters. And the other thing, I suppose, is this inquisitorial or quasi-inquisitorial role for the court, however that happens to be implemented in practice through delegation of actual action, because those two things together, hopefully, I mean, ultimately the situation just is more difficult where you have somebody who's acting in person, hopefully slightly less difficult where they at least have a legal representative at hearings. But yeah, we have made recommendations which I hope try to close some of that gap, although I don't think anyone could pretend that having a litigant in person is always going to be as straightforward as where both parties are fully represented.
Could I just ask, because I mean, I think it is a really good point that we didn't really think about direct access, to be quite honest, but what would happen in practice now if a direct access barrister takes instructions, meets the client and thinks, I think there's a real problem here. I'm not sure I'm confident that I can take instructions from this person. I'm not sure they have capacity to give instructions. What would happen at the moment?
Well, they'd have to tell their client that they have that concern, and they would have to tell the client they have a duty to bring that to the attention of the court. But it's extraordinarily difficult because they don't have any other ongoing, beyond the instruction for the day, responsibilities to the lay client.
Yeah.
Yeah.
It's just that I think that, again, it's not our responsibility to do this, but I would hope that any new professional guidance would cover that sort of situation. What would be the duty of a direct access barrister in that situation? Yeah,
that's why I raised the title legal representation covers a direct access barrister, but in these circumstances it would be for the purposes of the civil procedure rules generally, but for these purposes it would need to be singled out as a separate item to be considered by the court.
Yeah, I just hope it would be something that the professional guidance could cover the different ways in which barristers are instructed. But it isn't something we did direct our minds to, I have to say.
I guess moving across the room left to right.
I'm a retired district judge, and quite often when I used to sit, the effect of this issue would be to entirely stop proceedings. They would actually stop and they would never be resumed. And I can remember, for example, possession proceedings where a defendant tenant might show up with a family member. The family member might say, this person was sectioned 2 years ago. Well, raises a concern in the eyes of the court, and zilch. We used to use I used to hand out the form which was used by the official solicitor. Now that form, at least at the time, was 16 pages long, of which 9 pages were guidance, which was supposed to be compulsory to read. And frankly, no GP, none, would do that in my experience. And so I think that the dual approach of non-means tested legal aid, where people are represented, is almost a no-brainer, frankly. And there aren't, in my experience, at least in London County Court, that many of these cases. The burden on the exchequer is not going to be that great, I think, from that. But there also needs to be an ancillary power for the court effectively to make a similar direction in some way or another to deal with unrepresented parties, because there isn't any other effective way to do it. And in my experience, it just kills the cases completely, flat dead.
That came out in the consultation, and I think our remit was relatively limited, but one district judge, actually it wasn't a district judge, sorry, a solicitor from a charity, was saying you have really good practice of district judges adjourning possession proceedings and saying adjourn to get a medical report, a GP report, and the party never comes back. They either try and the GP doesn't know what they want or doesn't give it, or it's expensive to get back to court and it, as you say, the case collapses. But if it's possession claim, it may not collapse. It may end up in a possession order if the tenant doesn't return to court. So it raises much wider issues about the lack of support for vulnerable litigants generally, I'd say.
By me, I thought this is actually a very good idea, not very fair for explaining, but I felt, and sometimes, yes, it would end up a year later in the making of an order, but effectively it's plainly unsatisfactory to both parties.
Yeah, well, I mean, I think it's part of what this report is intended to give the court a greater range of tools to address. I mean, ultimately, I can't suggest that this is going to provide a perfect solution for every case, but things like, for example, a clear power to order disclosure of medical records. I mean, I've had so many cases where the court's going, do we have power? We need doctors' records, but the party's not going to consent to that. Doctors don't know whether they can do it. I don't really know. Third-party disclosure orders aren't really very well tailored to this. And so the approach that we've taken, I think we set out in the report, is to kind of try to put together a tool set, because the range of cases in civil justice is so wide and the demands of justice in any given circumstance are going to be so different. Really, it's about setting some overarching principles and then looking at specific obstructions or difficulties and trying to create tools to deal with those. And ultimately, as with so much in the justice system, a lot will be down to individual judges using those tools in the way that the case demands.
And I think actually, talk about a positive duty, and surely the court must do this. I have to say, I think that the problem is the judges are so variable, and many judges will not have that in mind. And if the tenant doesn't turn up at the next hearing, or it's a different judge anyway, a possession order will be made. And that's why I think training of judges, and as you say, this kind of a toolkit, but more clarity for judges as to what's expected in a case where this issue has been raised can only help, I think.
Hi, I'm Julia Clark. I'm a Chancery Master. This is a big problem for us. And we did have a very good talk not long ago from one of the judges of the Court of Protection, who explained to us, and I don't pretend to be an expert on this, that they have a jurisdiction under Section 49 of the Mental Capacity Act to carry out a sort of inquisitorial investigation. So I don't know if you know about this or you've talked to the Court of Protection, because as she explained it to us, they can either appoint a visitor or they can actually compel the local NHS or the local authority to prepare a report for them on the capacity of the person. And that person has the power to go and get the medical records, even if the patient or the person who's thought to lack capacity doesn't consent. They can just go and get the medical records, because, you know, one practical example for us is someone appears in, you think they lack capacity, you direct them to go and get a report from their GP. They don't, and you can't force them. So, you know, you're just left in this evidential void. Whereas it seems to me that this procedure is capable of fulfilling that evidential void, and that would be a procedure you could consider modelling, or even, you know, giving that power to the Court of Protection, because they're the experts.
We did have a lot of discussion on this, didn't we? And we had a lot of real expert COP people on the working group, judges who are COP ticketed, as well as practitioners who've got loads of experience. And I think we did discuss this power, and one of the things that was discussed and rejected was the notion of transferring to the COP for this determination. And I think we did all agree that no, that wouldn't be right, because it's the duty of the civil courts to recognise that they have to deal with capacity in the civil courts, and the COP wouldn't have the capacity to deal with these kind of referrals. But certainly we did look at those models, didn't we? And I think that's...
And I was just looking at what we recommended. I mean, there's both a power to call for reports from treating clinicians, which we had some people from the NHS who were very sceptical about the idea of expanding the court's jurisdiction in that regard. But, you know, we have to recommend what we think will be a sensible solution. And then there's also medical visitors, which I think you were talking about, in terms of people going to make assessments. And certainly the report considers those and recommends that the creation of equivalent powers for the civil court should be considered in relation to issues of capacity.
Thank you, because it's been great.
Yes. I'm Pamela Rowe from British Housing Rights. So we run possession schemes, and I think the issue that this lady raises there is similar to ours, because what is not necessarily solicitors that are at court representing clients. Often there's a difference, because you can see someone. Often people don't obviously lack capacity. That's the point. It becomes clear as you're speaking to them, and there is an issue about whether or not they want. There's a conflict between you saying I can't act for you because you lack capacity, and then you've broken your trust because you go and tell the judge, etc., etc. So I quite like the idea of this whole thing where you're taking it away from the advisor, because then they can still maintain their professional relationship with that person afterwards. But there is it's not easy, I think is what I'm saying, and there are nuances that perhaps you haven't considered, because a good amount of court users aren't solicitors. So when I have my relationship with my client, I'm very clear about what that is. They're sitting in the room with me and I can deal with them. But when you're dealing with people on the run, it can be more difficult. My experience of London courts is, in fact, unless somebody is clearly on the other side of the line, judges tend not to want to adjourn cases because they've got other mandates. And so you get this tension where people are, or somebody's come out of hospital, which is ostensibly meaning that they are well, but clearly not, right?
I think on this issue of concern about losing sort of trust of your client, as it were, it seems to me that kind of one's overriding duty of the court comes into play as well here, insofar as if you have that concern about your client's capacity, but they're not kind of with you on it, I think it's a situation where the solicitor or the representative should look at the duty they've got to the court and say to the court, I've got concerns here. And I think what the lady said here about having a visitor or someone who's going to go and assess that in the way that CAFCAS does in family cases seems to make very good way forward, as it were, to sort out that sort of issue, because it is difficult. I've had a number of cases recently where it's been very clear that someone lacked capacity, and they're more straightforward. But it's the ones that are, I haven't had one in court where it's more questionable, and I can see that what you're doing is very important work to try and find a way through it.
Yeah, thank you.
In terms of judicial training, I can tell you that the Judicial College for at least 8 years has had a capacity module which is changed frequently. It's currently 3 hours, and I last taught it last month. You might want to have a look at it and make sure that it covers all the things you think it should. Did I understand you to say that it should be compulsory, because it's not at the moment?
That was, I thought, it was one of our judicial members of the working group who said it should be compulsory and updated on a regular basis.
I agree.
Yeah, yeah.
Sorry, can I very quickly, just as I ask as a current district judge, what the perceived, slightly a concern, alarmed even, to hear that there's some sort of deficit amongst the judiciary as to recognition of something. Is it failure to recognise a lack of capacity or failure to act on it that concerns the CJC most?
I don't know that we have enough data, there's no research to say what the real issues are. It's very much anecdotal. But the evidence seems to be both that it's a busy list of housing possession claims. You don't have very much time to work out if there's an issue with the party who's unrepresented. If there's a duty advisor, that's great because they can intercede. I think it's a problem with both, but I think the impression we had was that the practice is very variable. And some district judges are excellent at spotting and acting appropriately, and some are perhaps, we think, using the presumption of capacity to just move on and not picking up. And that's why we felt, I think, that there needs to be clearer training and guidance for judges and representatives.
Hi, so yeah, this is a problem which comes up time and time again on the duty advice scheme when we're trying to give advice at court to people. I just thought perhaps one way of reducing sort of the tension between the conflicting obligations is to look at the ways in which the process as it is, if a person's found not to have capacity, can be very much against the best interests of people who have serious mental health issues. So, for example, capacity is a very nuanced thing, and people can have capacity to make some decisions and not other decisions. So a person may not have capacity to conduct the full extent of litigation, but that doesn't mean that they can't necessarily make certain decisions within that. And there's a sense in which having a litigation friend appointed, the person can risk losing an awful lot of agency in relation to those proceedings in decisions which they may very well be able to make themselves. So I think we need some clear guidance and better guidance for litigation friends on the extent to which they are required to involve the litigant in that process. I'm also extremely concerned about suggestions of compulsory release of medical records, because I think particularly people, again, with PTSD, who have a background with familial abuse, domestic violence, being required to disclose extremely confidential medical records simply because they're being brought to court by a landlord for rent arrears, that in itself is a huge bar on access to justice, because many people will simply walk away at the prospect of being required to disclose very personal information. And that in itself will push people into not having capacity. The possibility of that will push people into crisis and trauma. And I think it's not, a lot of that medical background won't be relevant to the just straightforward issue of whether the person has capacity to deal with this particular decision today.
Can I say I really share those concerns, and also not just the PTSD issue and the wider issues. It seems to me that many people who may lack capacity are often, if in my experience, if they have a relationship with a GP or a clinician, that's great. And to undermine that by forcing the doctors to disclose information such that the person may then cut off from the medical experts. I think there's real issues about, we can say as lawyers, a power to order disclosure sounds great. I think we have to really look in practice. And one of the recommendations is consulting with medical practitioners and more widely about what will be the impact of ordering disclosure against someone's wishes. I have real concerns about that. I agree.
The other thing to say, I mean, in relation to that, you'll see in the report there's a kind of the recommendation that there should be a power that exists, and there should be relatively restrictive guidance to ensure that it is only used to the extent that it's necessary and proportionate, where other kind of less intrusive methods can't resolve the issue of capacity, because ultimately there's a trade-off between somebody's rights in relation to privacy and confidentiality, but then also making sure that their substantive rights are protected in the proceedings, which in a particular case might not be possible unless the court's able to progress with that decision as to capacity. It also interacts with the other kind of difficult aspect of this, which is there's throughout the report a consideration about to what extent, if any, other parties to the proceedings should have any role or input into the process of determining capacity. And that, it seems to me, is a very important thing, that if records are being disclosed, then, I mean, so my position, I think, is that the starting point is that none of that should be available to the other parties in the proceedings, unless there's some kind of very good reason why they have to be given a right to be heard on it. So there's ultimately a trade-off, but even when that power can or should be appropriately used, I think there are also still safeguards about the extent to which the records are disclosed at all to the court, and then obviously restricting any knowledge of those records within the proceeding. I mean, obviously, litigation generally can involve disclosure obligations in relation to medical records, which parties would otherwise keep confidential and private. But here it has to be particularly restrictive in circumstances where somebody might not have capacity to defend their own interests in that respect.
Can I just add? And I think one thing that we are very aware of, this is the first step, and I feel like much more research and data is needed for what's actually happening. As I say, we don't know the extent of the problem, and I would like to know more about what does happen if someone who may be quite vulnerable and have private information they just don't want to disclose to anyone, what happens to them? Do they drop out? Do they participate? I mean, when we heard evidence of good practice, district judges adjourn for a medical report, that sounds great, but then you hear the experience of people are saying yes, but the client drops out because they can't afford the second journey back to court, and they just drop out because they've been to court once and the GP didn't help. I think we just need a lot more evidence actually about what happens on the ground, and it's not just a matter of rules. And this is the first step in just trying to say there is an issue that needs to be addressed. And it's definitely not one size fits all, one rule, but it's more guidance, more training. And I just think more information about what's actually happening to vulnerable litigants in our court system at the moment. I don't think we know.
Charlotte Steinfeld, I'm a barrister and a commercial mediator, and thank you for your consultation document and for your report. I haven't read the report yet, but I'm looking forward to doing so. I just recently had a case involving the determination of capacity by a district judge. It was my first time being involved in a case like that. And the judge was excellent. She was really thorough, because the other side was actually the defendant, and the claimant was alleging he lacked capacity. The other side claimed that he did not have capacity, and that the judge should just go ahead and appoint a litigation friend. And obviously we have to be really careful, because litigants also have human rights, and they need to be able to participate in the process if they can. And obviously if they can't, they ought to be helped. And I think to this district judge was very thorough, and I was really impressed. And I did refer her to your consultation document because the report wasn't out at the time. But I think in relation to the medical evidence, if I can make an observation on that, there has to be a causative nexus between the impairment and the decision making. And oftentimes I think perhaps judges are quick to ask for medical reports, but they have to be really careful. And I think they need to remember that, be confident in assessing whether that causative nexus is made out in the medical report, and not just assume because they have medical reports in front of them that the person must lack capacity. It's another step that has to be gone through. And also, I think judges need to be given the confidence and reminded that they are the determining panel. What's the word I'm looking for? The determiner of capacity in all the circumstances, not just the medical evidence. And I think the Court of Appeal, in a case of Khan, recently highlighted this, that the judges don't have to take the medical evidence as they can obviously use it as part of forming their decision generally, but they don't have to accept it. They can look at all the circumstances and make a different determination.
I agree, and I think there's also case law that suggests that in many cases, actually, it's not medical evidence that's going to be the best evidence, but family and friends and people who know the person, and it's a bigger issue than just a medical report, as you say. Sorry, you raise another issue, which I think we have to address as well. It's actually about the general professional obligations on legal representatives when they are facing litigants in person, which, whatever it says on paper, there's a lot of very bad practice out there. And I think that professional regulators need to be clearer about that.
How many more questions will the panel want to make now?
We can take a couple. We should try and finish in the next few minutes, shouldn't we? Give people a short gap.
Sorry. Yes, please. So we just take one more question. Is that right?
Thank you. I'll be quick. You've emphasised more than once that this is the first stage in a process. The very obvious next stage, of course, having determined a want of capacity, is to appoint a litigation friend. Because without a litigation friend, in reality, everybody accepts, I think, that the action will in most cases come to an end. The official solicitor is regarded as the litigation friend of last resort, but as we know, the official solicitor won't act unless there's funding. Do you envisage circumstances in which the fund of last resort that you refer to in the report might be used to fund the litigation solicitor acting as litigation friend? And if not, do you see a pretty swift follow-up CJC report looking at litigation friends? Because otherwise we find ourselves halfway up the hill with the handbrake off.
I mean, I think we were very, very conscious that there was a big issue about litigation friends, their suitability, the rules around cost undertakings. I mean, I think it's a big problem. We were very aware of that, but it was just one of those things that we could not include in this. I would welcome a sort of separate inquiry into how the litigation friend role is fulfilled and the understanding of it and the rules around it. It's really difficult.
The strategy meeting in January, and you'll be asked in a feedback form that you'll get shortly after the event if there's anything that you think that we should be looking at. I think just kind of reflecting on how the CJC sort of works, it was really interesting being in the working group discussions and in the consultation event, and here, I guess, when the reports come out as well, it's clear that it very much is the start of a discussion and that there are loads of issues that are still ongoing. But the way that CJC works is we make recommendations, and it's really good that we've got a recommendation in there for this council to come back and look at it, because that incentivises us to go to the people that we've made recommendations to and say, we recommended this to you, great, it's been done, or can you give us a bit more information about why it wasn't done? And then there's possibly even other issues that will kind of fly off from that.
Yeah. Is time up? I think it is. Was that your final point? Thank you very much, everyone. It was great.